I'm 69.
Welcome.
So you're just,
I'm a baby.
My name is Gerald Neuman, and I'm one of the directors of the Human Rights Program here at the law school. And we're very happy to have you here to listen to this and participate in this, I hope, extremely interesting panel on the subject of decriminalization and human rights. This panel is being co-sponsored by the Human Rights Program and the Criminal Justice Policy Program. It's part of a broader project in the Human Rights Program on criminalization and sexual and reproductive rights, for which we are grateful to support from Wellspring Advisors. And that is a project that we've been engaged on for a while. There'll be a number of events this year relating to this project, and it is work that we are going to be continuing into the future. On the subject of decriminalization and human rights, I just want to reminisce for a moment and say that my own interest in this area was peaked when I was a member of the UN Human Rights Committee, and periodically the Human Rights Committee was recommending decriminalization of various forms of activity, and sometimes it was obvious that the thing that was being, that the state was being recommended to decriminalize was itself a human right. You can't prohibit this activity. You couldn't prohibit it civilly, and you couldn't prohibit it criminally. But at other times, there were recommendations against criminalization of certain forms of activity that were not based on that kind of argument. And so the question, what is the range of arguments for decriminalization other than you've got a right to do this? From a human rights perspective or from other perspectives. That's the topic that we're going to be talking about today. We have three speakers who are going to help us understand these issues. Immediately to my left is Emily Nagisa Keehn, who is the Associate Director for the Academic Program in the Human Rights Program. Before she joined us, she was the Head of Policy Development and Advocacy at Sankey Gender Justice in Cape Town, South Africa, where she directed strategic litigation, parliamentary engagement, research and advocacy relating to HIV and AIDS, gender equality, sexual and gender-based violence, policing, and penal reform. To her left is Carol Steiker, who many of you may know. She's the Henry Friendly Professor of Law, and she's the faculty co-director of the Criminal Justice Policy Program here at the law school. Her work ranges from substantive criminal law to criminal procedure, to institutional design with a special focus on issues relating to capital punishment. And her most recent book is Courting Death, the Supreme Court and Capital Punishment, published last year, written with her brother Jordan, who's a professor at the University of Texas. And to her left is Douglas Husak, who's a professor of philosophy at Rutgers University. He has degrees both in philosophy and in law, and works primarily in the intersection of moral philosophy and criminal law, with a special interest in drug policy. Among his various books, let me mention Drugs and Rights from 1992, Overcriminalization from 2008, and Philosophy of Criminal Law Selected Essays from 2010. So without more, let me ask Emily Keehn to start us off.
Thank you, Jerry. Great. So as Professor Neuman mentioned, the Human Rights Program has been inquiring into the decriminalization of offenses relating to the inappropriate regulation of gender, sexuality, and reproduction for the past few years. This last year, we wanted to expand our focus and look at the broader context. What does human rights law have to say about decriminalization? What does it have to say about the topic of decriminalization writ large? And our interest is connected to concerns that are raised around what some describe as the penal turn or the untrammeled expansion and the increasing punitiveness of criminal law. International human rights law is a source of new criminal norms because national legislatures might sometimes choose to adopt or repeal offenses in order to comply with their international obligations. But much of the scholarship on the topic of decriminalization doesn't necessarily come from human rights scholars. It comes from substantive criminal law scholars and legal philosophers. Important scholarship, for example, might study empirically the scope of criminalization. It might develop theories and principles that articulate the constraints for criminalization, or when the state might rightly exercise the power to punish, to stigmatize, to deprive of liberty. In the human rights arena, this type of theorization is a lot less common. You see much of the existing scholarship tends to examine specific types of criminal offenses and asks whether they're just or appropriate, what the consequences of criminalization are, what the arguments might be used against it. A lot of the discussion is consequently quite issue-specific and relatively siloed. Other human rights scholarship might broadly critique the current relationship between human rights law and criminal law. For example, Francois Tolkens has helpfully considered the appropriate balance for human rights law to strike between acting as a sword versus acting as a shield, and has been wondering about a shift in the human rights movement from primarily serving as a defensive tool against state oppression, often exercised through the criminal law, to reaching offensively to the criminal law to vindicate rights violations. Others try to understand the paradox of attempting to implement human rights within highly retributive and often rights-infringing criminal justice systems. For example, what does it do to the human rights movement to align with the carceral state, or to call for more criminalization in a context of mass incarceration? So there are a lot of complicated anxieties, and we wanted to understand more. And we decided to begin by mapping the frontiers of decriminalization in international human rights law. And we started with the jurisprudence at the UN human rights bodies. These bodies are a complex system comprised of dozens of mechanisms. There are 10 treaty bodies. There are 56 special procedures of the UN Human Rights Council. Then there's a universal periodic review in which all UN member states participate. So the various human rights bodies approach the question of decriminalization in ways that reflect these differences and complexities. It's often unclear what they're referring to. For example, when they make a recommendation to decriminalize, are they talking about de jure decriminalization, de facto decriminalization, depenalization? Are they looking at legalization, or are they simply describing the social practice of criminalization, the way laws are interpreted, enforced, and resourced throughout the criminal justice system and wider society? Nonetheless, we mapped the jurisprudence and identified 26 types of offenses that we grouped into 9 categories: broadly, sexuality and gender reproduction, thought, religion, and conscience, migration and trafficking, land and property, opinion and expression, assembly and association, poverty, child and adolescent behavior, and drugs. And a lot of the offenses in these categories might be those that you already readily think about: sex work, drugs, abortion. Others might come to mind less immediately: witchcraft, nomadic practices, memory laws, homelessness. Examining the arguments articulated in the jurisprudence, it's not so easy to categorize the offenses that we identified according to the normative arguments that the bodies deploy. The various human rights bodies leverage multiple arguments of different kinds for each type of offense that they're examining. But at a high level, we might distill these into arguments that raise concerns with the offense itself, that raise concerns with the application of the offenses, and those that raise concerns with the overall effect. So in terms of the offense itself, just to name a few, it might be that, as Professor Neuman said, that they target and forbid the exercise of your human rights, for example, apostasy and the freedom of religion. It could be that they're defined in explicitly discriminatory ways. Perhaps the harm they seek to prevent is too insignificant to leverage the criminal law for. It could be that they're defined in ways that make it vulnerable to abusive application, so overly broad or vaguely worded. Anti-terrorism laws might come to mind here. In terms of application, the crimes could be enforced in discriminatory ways. So adultery or moral offenses, which are applied against women but not men, are as an example. It could be that they're applied in ways that are entirely counterproductive to their purpose. For example, anti-trafficking laws that are enforced against victims of trafficking for participating in their own trafficking. In terms of the effect, an argument that's raised is that criminalization is an ineffective policy overall. It produces greater harms than it seeks to prevent, or it simply doesn't work well enough to prevent the harms it's designed to address. So there's not time to go through everything, but just picking a couple of examples, it might illustrate how some of the multiple arguments are deployed in the directions the jurisprudence is taking. So looking at sex work, a tried and true example, it's a subject of vigorous debate. Many of us may already be familiar with the divisions, to put it oversimplistically, between abolitionist and sex worker camps. Given this prevailing dichotomy, the jurisprudence was a little more articulated and a little less uneven than you might expect. So there's not too much articulation, but the only treaty body to clearly make a recommendation on the decriminalization of sex work specifically is the Committee on the Elimination of Discrimination Against Women. Others might discuss it, but don't necessarily make a clear recommendation. It's been skirting the question since the early 2000s, but from 2010 onward, it's made recommendations in its concluding observations for states to decriminalize sex work, although it doesn't state specifically whether it means just the demand side, just the supply side, or practices around it. But their recommendations do state that this policy should be accompanied by regulations and programs to assist sex workers to exit the trade. Their arguments largely rest on criminalization increasing vulnerability to violence, to ill treatment, to blocking access to justice for sex workers, all resulting from the marginalization and stigma that criminalization produces. The Special Rapporteur on the Right to Health has also recommended decriminalization, but stated a little more clearly that he meant all practices around sex work. He argues it's a barrier to access and delivery of health services, resulting in poor health outcomes, particularly in regards to HIV. In essence, his arguments are that criminalization is without justification on public health grounds. The rapporteur on trafficking 10 years ago was very clearly abolitionist and put great stock in the importance of expressive condemnation through the criminal law. But 2010 onward has also been more agnostic, being unclear whether the Swedish model or demand-side criminalization reduces trafficking, or indeed which legal regime is the one that fuels sex trafficking. Instead, they focus on urging states to address the structural drivers of trafficking, as opposed to getting stuck on the question of crim versus decrim. In general, the bodies don't consider criminalizing sex work to forbid the exercise of a human right in itself, although that might be argued. In general, they view sex work itself as harmful, as conduct that should be prevented, a trade that sex workers should be assisted to leave. And overall, the concern is that the harm that criminalization produces is just too great. Similar arguments are deployed around the decriminalization of drugs for personal use and possession, as drug control and enforcement is a primary of human rights abuses, and as personal use and possession are increasingly considered through the right to health lens. Another category I'll look at is poverty and homelessness, which can refer to specific laws that are crafted to place heavy burdens on homeless people and people living in poverty. The jurisprudence looks at specific offenses, for example, those that prohibit life-sustaining or essential bodily functions performed in public, like eating, sleeping, or urinating, or defecating. Others might specifically criminalize efforts to earn a living through street vending or panhandling. Often these offenses might be accompanied by fines that the accused are unable to pay and serve to disproportionately funnel the homeless and the poor into detention. The Human Rights Committee and the Special Rapporteur on Extreme Poverty have stated that punishing conduct that's biologically necessary or necessary for survival can constitute cruel and inhuman degrading treatment. The Special Rapporteur has also argued that that these offenses are discriminatory in their intent or application and wrongly intensify the marginalization of vulnerable people. The disproportionate impact of these types of laws on racial and ethnic minorities is also raised, for example, by the Committee on the Elimination of Racial Discrimination, which remarks on the way that some of these laws might violate the obligation of states to ensure equal rights and access to any place intended for the general public. The arguments overall are with the offenses themselves and with the way they're applied and with their effect. They raise concerns with the overtly discriminatory ways in which they're defined. They're not convinced that the conduct they punish is harmful enough to warrant criminalization, and that it punishes behavior that cannot be helped or conduct that is not blameworthy. So, in closing, what does this research have to tell us, or where to from here? The jurisprudence doesn't demonstrate a unified approach or necessarily give us guidance on the question of what constitutes appropriate or just forms of criminalization overall. It deals heavily with the evidentiary foundations for decriminalization, which could be helpful to actors when they're considering the consequences of introducing new offenses or maintaining certain offenses under the criminal law. Additional inquiries might examine what actors in international human rights systems argue should be criminalized. It might be informative to know what topics and with what arguments human rights actors urge and influence the expansion and punitiveness of the criminal law. I'll close by saying that looking at the overall jurisprudence might also help guide the development of human rights principles on criminalization in the future, as scholars and practitioners begin to work to identify and distill constraints on criminalization using human rights framing. Thank you.
Thank you.
Terrific. Thank you, Emily. That was a terrific overview of the issues. I want to focus in on one more particular critique of the current landscape of criminalization in the United States and undoubtedly elsewhere as well, though I'm speaking from a domestic perspective. And this is a critique that is of interest and is part of the work of the Criminal Justice Policy Program here at Harvard Law School, of which I am the faculty co-director along with Professor Alex Whiting. And this critique has to do with what we call, and many other people call, but within our little organization, we call the criminalization of poverty, and the ways in which the criminal law ends up penalizing, often through its most coercive aspects, that is through incarceration, people simply because of their poverty. And so when we talk about the criminalization of poverty, we might mean one of at least three things, but here are three different aspects of it. One is one that Emily just touched on, which is crimes of poverty. So crimes of homelessness, which Emily talked about, laws that forbid sleeping in public or eating or lying down or loitering or urinating or defecating, even when there is no feasible alternative for people who are homeless to perform these life-sustaining activities elsewhere. This has been a big problem, for example, in Honolulu, in Hawaii, where the homeless have been swept out of public areas and often incarcerated in order to promote tourism in Hawaii. It's a big problem also in San Francisco, in which giant infusions of wealth have made it impossible for the people with the least means in the metropolitan area to afford to live there. Or another crime of poverty other than crimes of homelessness are crimes that derive from violating any of the very strict and often complicated rules around receiving public benefits. So many people think of this under the colloquial term welfare fraud, but whatever you think of when you think of welfare fraud, these crimes extend far more broadly. This is not sort of out and out intentional fraud where people apply for benefits to which they know they're not entitled. You know, there are cases where people have been sent to jail for selling their blood while they're on public benefit programs because that will push them past the limit on income that they're entitled to have, or receiving help in emergency situations from family members can constitute public benefits fraud. So there are a lot of there's the penal enforcement mechanisms around the public benefits system, whether it's food stamps or what's now called TANF, which used to be welfare, or supplemental Social Security, the disability statute that provides people with financial support for their disabilities, very strict regime. So that's one whole bucket of crimes that are crimes of poverty. Another way of thinking about the criminalization of poverty is the enforcement of neutral criminal laws that are not specifically designed or targeted at poverty at the poor, but that are enforced disproportionately against the poor. Now, many people might think, well, isn't that every law? But there's a lot that could go into this bucket about disproportionate enforcement of crimes against the poor. But one big bucket is school discipline. So, you know, I went to a upper middle class suburban public school, so did my children. There were never any police in sight except when they brought their cruiser there and let all the kids come in and push all the buttons. That is not true in many of the poorest school systems in the country. Now, it's true that perhaps more policing is needed in places that are more dangerous, but what often happens as a result of that is that ordinary school discipline becomes the subject of serious policing and criminal justice, what some people call the school-to-prison pipeline. That's just one example. Another is marijuana enforcement. So marijuana, as you probably know, has been decriminalized here in Massachusetts, at least at the low level of possession. But when that was debated just a few years ago, law enforcement was overwhelmingly against decriminalization. Why? Because they felt that it would interfere with their ability to enforce other laws in some of the roughest parts of the Boston area. So basically they said, how else are we going to be able to search cars and individuals on the street if the smell of marijuana doesn't give us, the probable cause that we need to conduct those searches? For example, I walk through clouds of marijuana regularly here in Harvard Square and in Harvard Yard, and one never sees the enforcement of the marijuana laws on college campuses, for example, in the same way that one would see it in parts of Roxbury, Dorchester, and Mattapan. So these are just examples of the ways in which laws are often maintained, not despite, but sometimes even because of their disproportionate enforcement against the poor. So those are two buckets. The third bucket is actually the bucket that comprises some of the work of the criminal justice policy program now. And to be honest, this is probably the most far afield from the topic, the criminalization of poverty. But nonetheless, we call the work that we're doing the criminalization of poverty. And it's around this third bucket, which has to do with policies that surround the administration of the criminal law that lead to the incarceration of poor people simply because of their economic status. So our projects in this area include working on bail reform and on fees and fines in the criminal justice system. So money bail is a somewhat uniquely American system, very widespread here in the US, where prior to trial, people are held if they cannot post a money bond that will assure their appearance in court. But in many places, these bonds are set on a schedule that is correlated to the offense that they're charged with rather than the individual's ability to pay. And so many people are held simply because they don't have the money, no matter what their crime is. If they're rich, they can get out. But if they're poor, they have to spend time in prison, often far more time than they would spend if they were convicted of the offense with which they're charged. And this is how the bail system is related to actual criminalization. Many people charged with misdemeanors choose to plead guilty immediately or as soon as they can because they will get out, whereas if they insist on waiting until their trial date, and in the overburdened criminal justice systems around this country, that can be months or even years before they are released, they will end up spending far more time in pretrial detention than they could possibly spend convicted of their crime. So many of you know of the story of Khalif Browder. He was made famous by an award-winning journalist, Jennifer Gonerman, who wrote a piece about him in The New Yorker. He's a 16-year-old kid in New York who was arrested, charged with stealing a backpack. It was never proven ever that he did such a thing. He insisted on his innocence and refused to plead guilty and was held at Rikers Island for 3 years. Much of it in solitary confinement. As a teenager, as a 16-year-old, 17-year-old, 18-year-old, he was released finally when he was 19 years old, and after suffering a lot of, what you've got to call PTSD as a result of that, took his own life after he was released. So that is the story of the bail system in New York City that is illustrative of what can happen with the use of money bail. There's also a lot of evidence to show that people who are detained prior to trial who cannot pay for their release are, one, much more likely to be convicted of their crimes than people who are released, partly because they've lost the ability to help work with their attorney on the outside. And they're also more likely to get longer sentences because they no longer look like such a good risk because they've probably lost their job and some of their family ties. So that's the one bucket of the work that CJPP does, which is working on the reform of money bail in the United States. And the second large project, and our policy director, Mitali Negrecha, is sitting here in the first row, policy director of our criminal justice debt initiative, fees and fines, that is user fees. Often if you go to to court, even if you're found to be indigent, you still have to pay various fees for court services, even for your public defender. If you're picked up on a warrant, you have to pay a warrant fee. There's lists and lists of all kinds of user fees, even for the indigent in the court system, and of course fines that result from being in the criminal justice system. And this results in a mountain of debt. One interesting thing, there's an act, part of the Massachusetts Criminal Justice Reform Act that's working its way through our state legislature right now as we speak. Part of that act, it's called an Act to Reduce the Criminalization of Poverty, talks about getting rid of, or not getting rid of, but seriously reducing the use of license suspensions in the Commonwealth of Massachusetts, because the most common offense at the lowest level of courts here in Massachusetts is driving after suspension of a license. That is the most common offense, and the majority of those people did not lose their licenses for driving offenses. They lost them for not paying their fees and fines. So this becomes a poverty trap. You don't pay your fees, you lose your driver's license. You lose your driver's license, you can't get to your job, and you can't earn the money to pay your fees, and then you go to jail. So this is a cycle that's really problematic. And this brings me back, so you're thinking like, okay, that's really interesting, that's terrible. What does this have to do with criminalization when we're talking about specific offenses and decriminalizing them? Well, one complication here is one of the answers to the problem of mass incarceration is to decriminalize. But as Emily had a helpful rubric in her comments about all the different kinds of decriminalization. And one of the most common, and in fact, it is the version of decriminalization of marijuana that we have here in Massachusetts, is that it's not a jailable offense anymore. It's not legal. You can't possess marijuana legally, but you'll get fined, you'll get a ticket, the way you get a parking ticket. But if you don't pay your ticket, you can go to jail. So this kind of decriminalization, which is very popular and very widespread for traffic offenses, for marijuana offenses, many critics of overcriminalization urge this with some success on legislatures to have a fine system and a ticket system rather than an incarceration system, has a dark side, which is that we then have a system of a wider system, a bigger web of fines and fees. And then when people can't pay them, they are swept up once again into incarceration through a multi-step process rather than direct imposition of incarceration as punishment. So it's something that we have to think about in considering decriminalization, which is very attractive in some ways, but ties into these collateral processes and consequences that can be of great concern. Thank you.
Thank you. Doug?
So as advertised or warned, I'm a philosopher, and a lot of people think that philosophers have little to say about real-world problems. I'm used to having eyes glaze when philosophers speak, and there's some truth to this. Philosophers have a reputation, and I'm sure I'm one of them, of having more questions than answers, and so that's the tradition I'll carry forth. I've long been an opponent of overcriminalization. I wrote a book with that one-word title, and I still am an opponent of overcriminalization. What is it? Well, it refers to conduct that's currently subject to punishment and shouldn't be. So I think it's a normative position, so the should here is a moral should. It's straightforwardly normative. And I tend to think of there being a conceptual connection between the criminal law and punishment. So I think if you want to know whether a law is a criminal law as opposed to some other kind of law, well, the criminal law just is that body of law that subjects people to punishment. And so if you're against too much criminal law, you're probably against too much punishment. One way to scale back the size of punishment is by scaling back the size of the criminal law. Not the only way, but that's certainly one way to do it. A lot of people, I think, do, in my judgment, confuse incarceration with punishment. I tend to think there's lots of ways of punishing people that don't involve incarceration. So many people are on the bandwagon these days of being against mass incarceration. I'm one of them. But you can certainly reduce mass incarceration without reducing the scale of the criminal law or even the scale of punishment. So I think when I'm against the overcriminalization, when I want to see certain kind of conduct decriminalized, doesn't mean just that I don't want to put people in jail. I want not to punish them at all, and there are lots of punishments other than incarceration. Surely, though, the next best thing to not punishing people severely is to punish them less severely. So that's kind of half a loaf. That's progress. If you can keep them out of jail and punish them less severely, well, that's progress. It's the next best thing to not punishing them at all. So I'm often sympathetic to that. It's worth mentioning that a lot of people dislike overcriminalization. I mean, by definition, it sounds like a bad idea. But like many projects, this is caught in political gridlock. It reminds me of mainly conservative politicians who purport to dislike government spending in the abstract, too much of it. And then when they're asked, well, what programs do they want to cut, they're not very forthcoming with examples. And so that's often what you find in this domain as well. People think there's too much criminal law, but when you get to specifics, they're not always on board with the same examples. Moreover, it's worth noting that there is a movement that alleges that we undercriminalize. And so let me just give you a couple examples that are probably examples with which you have some sympathy. There is almost certainly too little criminal law with respect to gun control these days. I mean, I would think many of you, I wouldn't be surprised if thought there were too many guns around this country. And one way to reduce the number of guns and the number of gun violence is through using the criminal law. And that would expand the scope of the criminal law quite a bit, because it may not be news to you that there are quite a few guns out there. And so you're going to be criminalizing conduct that many people engage in, gun possession, and that will inevitably, I think, expand the scope of the criminal law. Another example has to do with sex offenses, sexual harassment in particular. Again, no surprise to you to know that we're now much more conscious about sexual harassment than we used to be. And if one response is to criminalize behavior that we've previously winked at, well, that's, of course, also going to expand the scope of the criminal justice system. And so those are trends that are counter to, I think, the trends that many of us tend to support, which is to scale back the size of the criminal justice system and the scale of punishment generally. Well, there are really two ways to go about objecting to the use of the criminal law in a given kind of case. You can have pragmatic or procedural objections, or you can have substantive objections. I don't pretend that there's a sharp line between the two, but there are useful contrasts between objecting to the criminal law procedurally or substantively, and the procedural objections, roughly various kinds, but the most familiar are that you can't really enforce the particular statute in a kind of fair way. So enforcement creates problems greater than the problems it's designed to help. Or the enforcement is inevitably one that is discriminatory, typically along racial lines or along lines of poverty, as Carol just mentioned. So those are familiar objections, and that's all fine and well. I'm on board with all that. But I tend, as a philosopher, to be more interested in substantive objections to the use of the criminal law. And so to have substantive objections requires a theory, or if you don't like whole theories, you at least need principles of criminalization. And so there's many kinds of ways to formulate principles of criminalization. And my preferred way, not the only way, the way I tend to like to formulate principles of criminalization is in terms of constraints. So they're necessary conditions that any particular statute has to satisfy if we are to allow it into our criminal code. And so we need then, in my judgment, to think about what constraints to have, and you've got to formulate and identify these constraints. Then you need to defend them. Why should we accept them as constraints? And then you need to apply them. And all those are obviously incredibly tricky questions. They'll keep philosophers employed for a very long time, but that's, I think, where work needs to be done. One really interesting question is whether the interpretation and formulation of these constraints is going to be something that you can do without regard to a particular country in which these things are identified and applied. So are the constraints you'd accept in South Africa going to be the same as the constraints you identify here in the United States, here and now? Those are interesting questions about which philosophers can disagree. So, at any rate, you need constraints, and the one that I think is the least controversial in the abstract is a wrongfulness constraint. So I think, though it's challenged more often, virtually everyone accepts it, I think. So to give this any kind of content, you need a theory of what's wrong. And there's a good philosophical question for you. Theory to identify what's permissible from what's wrongful. Of course, philosophers tend to think about wrongfulness not just sociologically. You don't just go out and ask people, what do you think about this? Is it right or is it wrong? You need arguments. And so for any kind of conduct, before I think you should accept that conduct as a legitimate subject of criminal law, such that we have statutes that punish people who engage in it, it's always a fair question to say, well, what's wrong with that? And so unless that question can be answered, I think we shouldn't criminalize the kind of conduct in question. It seems to me just to be Kafkaesque to punish conduct that we think isn't wrongful. So what are examples? Well, we know, we've heard about marijuana decriminalization. I've been long an opponent of drug criminalization. A lot of progress in marijuana reform, no doubt, nothing you don't know, but there's been astonishingly little progress, or what I take to be progress, outside of marijuana. And so here's just an example, a fictitious example, I'm happy to say. I reach into my pocket, I pull out a vial of cocaine, I spill it on the desk, I chop it up and sniff it, and then the question is, what's wrong with that? Okay, what's wrong with that? And I'm not saying you can answer that question. I'm actually skeptical that you can, but I'm all ears. I'd like to hear the answer. And unless there's an answer, then I think that kind of conduct should be decriminalized. And by that I mean shouldn't be punished. I don't mean punished with a fine. I mean shouldn't be punished at all. So that's my position. I actually think there was a time when this was super radical. Now it's only mildly radical. I actually think I've never heard a good argument for criminalizing the use and possession of any drug, frankly. And so that's a view, and that's what needs to get contested. The way to contest that and to challenge that and to question it is by looking at wrongfulness. What's wrong with use and possession of any drug? So pick your drug. And, I'm not saying there aren't answers. I'm skeptical, but that's, I think, what we need to look at. Also, philosophers used to accept a harm constraint, so you had to actually be able to show, just as what's wrong with that, well, what's harmful about that? You may be surprised, philosophers tend to be rejecting a harm constraint these days. It's less popular than it used to be, but you can kind of smuggle it in because a lot of wrongful conduct is wrongful because of the harm it causes. So we then can get a harm constraint into our criminal law. Another is a desert constraint. You don't want to punish people unless they deserve it, and that's interesting too because one punishment requires not only that you breach a statute, but that you do so without a defense. So you can retard punishment by enlarging the scope of defenses, just as you can do it by contracting the scope of offenses. So that's another place to look. I think the best place to look there would be the defense of ignorance of law, which I think is used far too narrowly. We should expand that, and that will help retard the scope of punishment. Well, let's see. Feinberg, Mill, these people also thought that there were constraints against the use of the criminal law when people harm only themselves. So maybe paternalism should be ruled out criminally. That's an interesting topic about which many of us have strong views. Mill himself, of course, was against using the criminal law to punish offense. I think that the use of the criminal law to punish offense actually is maybe more popular than it used to be just 10 or 20 years ago. That's another area about which reasonable minds disagree. Well, there's a whole lot to say here. I've been told about 3 minutes ago that I had 2 minutes, so I exceeded my time. Philosophers can go on and on. I think we do have a little time for Q&A, right? And so let's leave it at that.
Thanks to all the panelists. And we do have time for a few questions. We're going to have to clear the room at 5 to 1 because there will be a 1 o'clock class. But are there questions from the floor, either to the panel in general or to a panelist in particular? Here I see a hand.
Thank you all. That was a really fantastic panel. Just to bridge the two concepts in the name of the workshop, have there been efforts, and have there been successful efforts to utilize international law and human rights law to try to rein in the U.S.'s mass incarceration system or mass punishment system?
Ooh. I don't know how much international actors do that. I think this topic has been raised in UN fora, but I think it's largely the purview of domestic civil rights actors who may not necessarily draw on human rights framing, even though they're engaged with human rights. That makes sense. Yeah.
Yes, I think I would respond by saying successful efforts persuading legislators to change the law because of international human rights objections, I can't really point to much of that. Raising the questions in international human rights fora, both regional and global, and receiving recommendations of particular kinds. So, for example, decriminalization of poverty, decriminalization of homelessness. Definitely there have been recommendations of that kind directed toward the United States from the international human rights bodies. But this is unfortunately not a country in which international human rights arguments that don't resonate with the domestic constitutional framework often produce domestic reforms.
I'll just add one thing to that, which is that in the constitutional adjudication of claims that punishment is disproportionate or excessive under the Eighth Amendment's ban on cruel and unusual punishment, the Supreme Court has adverted to the views of the world community. So until very recently, that was not at all a consideration in Eighth Amendment cases, but starting with a case called Atkins versus Virginia, in which the Supreme Court declared unconstitutional the death penalty for people with intellectual disability, what it then called mental retardation, now calls intellectual disability. For the first time, the court said relevant to its Eighth Amendment analysis was the views of the world community, and that became again essential when the court declared the death penalty unconstitutional for juvenile offenders and subsequent Eighth Amendment cases. So little tiny thing.
Please.
Just to follow up on that question, mass incarceration has a lot to do with the war on drugs, and I'm sure that you're familiar with the Sinclair family who has been pushing oxycontin that has turned to heroin. Now, when we look at it from the Sinclair family situation, that's okay to do that and make a lot of money and donate to Harvard. All these other institutions. And all of the people who are in jail have been dealing heroin and a lot of other things. So there's something wrong with that picture. And I wonder what your take on that is. Because there's a higher societal standard to mass incarceration and the war on drugs.
Well, let's see. What we have, as again, everyone in this room, I assume, knows, a current opiate overdose epidemic, I think, is a fair word. Maybe it's misused a bit, but we have a real heroin problem in this country right now. And of course, it's occurred in an environment in which heroin use is criminalized. And it's hard to see how we think our current regime is working very well since it's got us into the problem we're in. So I'm always impressed or surprised that people think the heroin epidemic is a good reason to retain the present course. I'm not sure this is responsive to what you're interested in, but it is an fascinating phenomenon that we now see occurring regionally, some places in the country more than others. And what caused it, what to do about it, these are really, really important questions. I myself don't think the criminal law is a big part of the solution. I think it's probably part of what's gotten us into the problem in the first place, but it's very complicated and not very well understood, I think. Not sure that's responsive. Yeah.
On the topic of marijuana decriminalization, I may be wrong, but if I remember correctly, one of the flaws that I recognized when reading through the law was it prohibited individuals from supplying a certain amount of marijuana to children under a certain age. It also prohibited those children from using the marijuana, but under the punishment section, it only punished the children and not the actual individuals supplying the marijuana. And I think when I read through the Mass General laws, it also didn't have a provision on that. So I think, since I don't have insider's knowledge of how this law was drafted, I feel like it was very sloppy drafting to begin with. And you also pointed out the problems we have with that system of imposing fines instead of incarceration or jailing. What would you suggest? Would it just be an outright sort of decriminalization in the sense that there are no fines, like no nothing for using or supplying marijuana, or would there be a better system? And this is only one example of it, but what would you suggest would have been a better way to deal with that situation?
Well, I'd like to hear what Doug is the master on
Well,
criminalization.
So I think there should be no criminal penalties for use of a drug. So let me give you the extreme to be, so I really mean what I say. I don't think it should be a crime for a 6-year-old to use crack. Okay. Now that's in a way sounds shocking, but in another way it's not. I mean, 6-year-olds shouldn't be. There are no crimes 6-year-olds can commit. So, and by drug decriminalization, I mean the use and possession of a drug. Sale is an altogether different thing. It ought to be a crime to sell drugs to a 6-year-old, of course. But the crime shouldn't be the crime of use or possession. So I'm not sure, again, there's a lot to say about all this, and I'm sure you know. If the statute is drafted in such a way that the criminals are the users, well, then I think it's sloppy draftsmanship. I'm not aware of the particular statutory scheme you have in mind. This is in Massachusetts? Yeah, I haven't actually read it, I'm embarrassed to say. Hard to keep up. Marijuana law keeps changing so rapidly, and what each state is doing is a little bit different, but similar to other states. And it really is a full-time, Carol's an expert on different state regimes for the death penalty, and you could spend as much time looking at marijuana law state to state. It would be a real full-time occupation.
Debbie?
I'm wondering about how you deal with sort of like the very different positions on criminalization in general, especially maybe on the policy implementation side. For example, people that say, we need to abolish the police, people that say, like, actually what we need is community policing. I'm a little interested in how that works its way into the work, or like the challenges of sort of like dealing with that kind of spectrum listening.
Well, that's a very broad question. I'm not sure exactly. I'm not sure exactly what you mean. I think that, what's interesting is that in the last presidential race, with the exception of the person who won the presidential race, most of the candidates, including most of the other Republican candidates, at least we're all on record agreeing that we have a problem of overcriminalization, of over-incarceration. This was not just a Democratic position. Ted Cruz and Marco Rubio and Jeb Bush were all saying the same thing. So there's become a consensus, I think, in our country that we've reached some kind of tipping point with regard to our penal policies. Despite that apparent agreement, after that, everything falls apart about what exactly that means we ought to decriminalize. It's, very much along the lines of, we ought to cut the budget, but, nobody agrees about where we ought to cut it. or can point to a place where we ought to cut it. So I think that's a real problem, and it doesn't, to get from the consensus that there's a problem to a consensus around a solution, whether it's decriminalization of drugs or, problem-solving community policing rather than, interdiction policing or in addition to interdiction policing, is really an open question and varies tremendously across the country in terms of what states and localities are doing to try to implement what appears to be a consensus that something has to change.
If I could add some thoughts on this from the international human rights perspective, you won't find international human rights bodies saying that the police should be abolished. What you will find is them constantly saying that the police need to be disciplined, there are certain things that police forces in most countries do that they should not be doing, that there should be independent mechanisms of accountability rather than just leaving it to the police to police themselves, and that sometimes criminal sanctions need to be imposed on police officers for the harms that they cause. So that's another area where the human rights movement is simultaneously looking for decriminalization in some areas, but more serious criminalization in other areas.
I would add that it completely depends on the context. For example, in South Africa, where I was working, there's a big question around just distribution of policing resources. So maybe there's a problem with an overcriminalization in certain senses, but there are also communities that completely lack policing resources and might be actually requesting additional police presence. So it's one thing to think about the complexities of that across the United States, but it's a much more complex question even asking across other countries.
So it is now 5-1. Thank you for your engagement, and can I ask you to join me in thanking the panel?